Hello everyone, we welcome you all towards our project Nyay. Our major objective is to teach the law in different kind of regional languages, starting from national to the international laws and regulations at a very affordable price. For more details, you can check in the description, and if you have already subscribed towards our courses, we would like to wish you all the best for progressing your legal journey.
First things first, before getting into the textbook definition of what actually mediation is, there is one certain story that a lot of mediators know about to explain mediation. It is a very simplistic story to understand the crux of what mediation actually is. Mediation is a very collaborative approach. So, to prove this particular point, we do have this story, which is very interesting, and I'll be telling you right now. So imagine there are two sisters fighting over one orange. Both want the whole orange, and the argument escalates before mom steps in. In an effort to stop fighting and to be fair to both children, she grabs the orange and cuts it straight down the middle to give it to each child so that they get halves of the orange. But unfortunately, this does not stop the whining of children. So little Emily, one of the kids, explains that she needed the whole orange to squeeze out juice to complete her orange cake for the school baking competition. While the other sister, she wanted orange to make a peel and make a face mask out of it. So this was a situation. The mother didn't know this until she understood the individual interests of both the children. She just made a solution that she thought will deem fit for the kids. So once she understood this, what she did was obviously she took the peel because for the face mask you do only need the peel, right? So she takes the peel and gives it to one child, and the pulp of the orange is given to the other, Emily, so that she can make a orange mask. So this is what mediation in a crux is. It tries to understand the interests of the parties and try to bring a collaborative approach for a win-win situation, right? So it's pretty interesting, right? So let's get into it more. Now, what is mediation? Mediation, in its definition, is that it's a very structured and a dynamic process where a neutral third party member, known as the mediator, facilitates communication and negotiation between the disputing parties. And the primary goal is to assist the parties in reaching a mutually acceptable resolution. So, this is very important because both the parties will want to have a mutually acceptable resolution. Now, it is one of the modes of alternative dispute resolution. Why do we say it's alternative dispute resolution? Because if there's any dispute, the conventional way of resolving that dispute is going to the court and filing a case. The petitioner files the case, the respondent comes and appears before the case, the arguments take place, there's a winner and a loser. Unlike this situation, mediation is more of a collaborative approach where both the parties voluntarily come together and try to solve the situation. Now, there are certain things that we need to know about mediation. First is non-adversarial process. What did it mean by non-adversarial? Non-adversarial systems are based on cooperation, negotiation, or dialogue rather than confrontation, competition, or trial, which happens in litigation usually. And here it also involves communication and collaboration, like we established earlier. Mediation is all about communicating one's needs, presenting the dialogues, and making sure both the parties are in a sort of a win win situation. It's very flexible and confidential. Uh, Mediation, unlike court system, does not have a fixed procedure, which is rigorous and time consuming. It is flexible based on the mediator's approach and the party's needs. It's also very confidential. Personally, according to me, this is one of the great assets of mediation, that it's confidential, unlike court cases, because when it's confidential, parties can tend to confide in the media or confide in the process a lot more and be truthful, and they can get into a resolution much easier. Now, what are the few benefits of mediation? One is that it preserves relationships. So, when you know that you can find a equitable solution for both of the parties, you tend to go back to the place where you were before the dispute. Now, say suppose two family members are having a land dispute, and if they go to the court, one will eventually get the land, or there's an unequal distribution of land, or there's some resolution where there's a winner or a loser, and there is always beef between the parties, right? At the end of the day, they will not be the same as how they were before the dispute. But in mediation, since we have a very collaborative approach, especially there is something that's coming up now, it's called a transformation mediation, where the parties are put back in a position where they were before the dispute arose. So this involved a lot of psychological aspects to it. It's still under the workings and it's not yet established, but this is one of the major milestones of mediation, that it preserves relationships. Next one being empowers individuals. Here, because parties themselves are negotiating, they are doing the decision making, they are doing promoting personal growth. This might be not so great benefit, but when you look at it, people have felt a lot more self satisfaction when they are actually solving their own case. Third one is that it's efficient and cost is effective. Of course, it's efficient because there are cases in the courts which have been going on for 10 to 12 years, which mediation has solved in just 10 to 12 days, right? So it's definitely effective, and it's very cost effective as well. Why? Because litigation involves the court fees, the advocate fees, and a whole lot of procedural fees that we pay. Mediation is way less costlier than that of litigation. Historical origin. Now we think that, oh, mediation is a very fancy term, it's so in vogue right now, it's new and all of that. But essentially, when you look at it, mediation was there long ago. If you've all heard about panchayats, um, this is a situation where village panchayats and nyaya panchayats have been functioning in villages, where there is sarpanch, the supreme member of the five punches, and they act as a mediator, and the disputing parties come there to resolve their disputes. This was a very conventional way back then, but then this was more done because there was no easy access to courts back then. Courts were far off, so villages just trusted their sarpanches to decide on their issues. But eventually, then courts were becoming more accessible, and there was so many backlog of cases that now it's overburdened and it's not being able to solve a lot of it. I think we know this scenario. So now mediation is a more what to say sophisticated and a more better approach in today's world, but the origins come from panchayats. Now, there are certain principles of mediation. Very quickly, let me get through it. The three principles of mediation are impartiality, self determination, and confidentiality. When you talk about impartiality, mediators are to be very, very impartial in terms of mediating a process. They are not the judge. They do not give the judgment to the mediation, but they facilitate the mediation. And self-determination. Although the mediator will facilitate the discussion there, he or she in no ways will take say that this is the resolution that needs to be passed. He will facilitate that, and the rest is on the parties to take autonomy on the decision. Confidentiality is when that mediators can be trusted. If at the mediator at any point in the mediation session discloses or not being helpful in the mediation session, the parties can stop the mediation then and there, and they can go back to their litigation procedures. So the role of the mediators is very, very important. That we will be looking into it in the further more units. Now that I think by now we would have already had an idea about what is the difference between mediation and litigation. Mediation is a very voluntary collaborative process, while litigation, on the other hand, is an adversarial and involuntary legal process. Mediation is quicker, has more control, provides a safe environment, is confidential, and supports relationships. I think these we have covered in the previous few slides. And I'll have to make one thing very clear here, that in no way that here we're trying to negate the importance of litigation. litigation. Litigation is absolutely important. We have statutes, provisions for a reason, and they are will come as necessary in every aspect of a dispute. But mediation will speed up the process, and it is very much helpful in a lot of areas. A lot of civil and commercial cases can definitely get into mediation for efficient way of dispute resolution, and it will sort of ease the burden on the courts as well. So, quickly comparing the different forms of alternate dispute resolutions. Now, how is mediation different from arbitration, conciliation, and negotiations? We'll have a quick run through. One is that in arbitration, the facilitator is called the adjudicator. He is no way a facilitator here. He acts as a judge. It's more of an informal process, more informal than of litigation, but it's a very formal process, arbitration. Mediation, again, it's an informal process. Conciliation is informal, and negotiation is informal. And a mediator is a facilitator in mediation, and in conciliation also the person is called a facilitator. In negotiation, we actually hear there's no facilitator in negotiation. There are just two disputing parties. They try and negotiate to come into a agreeable solution. Now, when it comes to legally binding, this is very important because in arbitration it is legally binding, like that of the courts. When there is a resolution given, the parties are bound to follow it. While in mediation, it up until 2022, it was not legally binding, but 2023, after the act got passed, after resolution has been found, it has to be given to the court, and the court will give a decree, and then it becomes binding, mutually binding on the party. Conciliation is not legally binding, and negotiation. I'm sorry, there's an error. Conciliation is not legally binding, and negotiation is also not legally binding. Right. Now, there are few challenges to mediations as well, as since it is a smooth flowing process, there are underlying problems, of course. One is high emotions. Parties tend to be highly emotive, at least when there is a law, they tend to like, not, we can say, yes, they are very scared of the system, and so they tend to be a little more submissive, whereas in mediation they have high emotions. They might get into problems in between before the mediator, so it's the role of the mediator to manage this efficiently. Power imbalance. So say suppose an employer and employee is going for mediation, so there might be a power imbalance and resistance to change. So mediators are also having problem to change the different positions and when the parties keep on changing the positions and interests. One very important case study, it's very interesting that this is the Agarcha Strip mediation between Burkina Faso and Mali. So Burkina Faso and Mali are 100. If you could see the picture here, Mali is on the left side and Burkina Faso on the right, and that there's a red line. That is the Agarcha Strip. So this is a 100-mile long Agarcha Strip, along with significant amounts of natural gas and mineral resources it has. Okay, where the border between the two countries should be drawn was a source of immense tension and two eruptions of armed conflict. First in 1974 and again in 1985 was happening. And the second conflict led to a very big Christmas war. So obviously this is an international dispute. It went to International Court of Justice. This after a couple of years they could not even resolve the dispute. They sent it to ANAD, this is a mediation center, where they tried and resolved a resolution very quickly that how much of the land will be taken by both these countries. Finally, they decided equal distribution and how much of equal distribution happens between these two countries, and you had a very good resolution by the end of the day. This was one of the very famous successful mediation cases that has to be known. That being said, mediation empowers individuals and communities, transforming conflicts into opportunities for growth, understanding, and sustainable resolutions. A quick recap of what we did today. We saw the definitions and principles of mediation, we saw the historical overview of mediation, we saw the benefits of mediation, and we compared mediation with all other ADR systems, which is conciliation, negotiation, and arbitration. And we also saw the difference between mediation and litigation. So I think this gave you a fair understanding of what mediation in a crux is. It'll be really interesting when we look further into different units and understand it on a deeper level, because it's just fun. It's absolutely fun, and it is the future for our country. So, yes, thank you so much.